And we're live.
Right, we are back in Senate Judiciary. It's February 7th, and we are picking up with Bob Paley from the Vermont Bar Association.
Good morning. Thank you. I want to first of all thank the committee for taking the time to set aside this morning to talk about civil justice. I've been watching obviously what you do here. Spent a lot of time on public safety issues. Looking at the civil side of our judicial system is, we think, equally important. I'm not here on behalf of the Bar Association asking for funding. We do run some projects, mostly what we call low bono projects, trying to recruit lawyers who are willing to do work at less than their normal rate, and really less than their overhead rate. We use those lawyers, those are grant funded operations, some grant funding from the foundation and some from the Vermont Supreme Court. But we try to fill in where services are lacking. The reason we're here talking to you is because you are the folks in this chamber that are the experts on how our justice system works. The document that I filed, the first document that I filed for today, is the coalition's request for funding in the amount of $500,000. Actually, $525,000 with that 5% extra as administrative costs for the VBF to handle a grant process. We asked the funding to go to the foundation because the foundation is really the charitable arm of the Bar Association. They are well experienced in grant, not writing, but granting. As you've heard, they grant legal aid money, legal services money, asylum assistance program money. I don't know how many, and maybe Hannah can tell you how many grantees they have. It's probably in the 20s. And it's my understanding that they grant out about $1 million a year. Where does that money come from? Probably you already know this, but that money comes from interest on lawyers' trust accounts, which lawyers like to call IOLTA. So our trust accounts, every firm's trust account, wherever they are in the state, that interest is not paid to that lawyer or to that account, but it's paid monthly to the Bar Foundation. So that's their income stream. That's the money that they spend. They will also engage in fundraising, usually, with the Bar Association as a partner. Obviously, a request for funding is a request for the Appropriations Committee. But what our hope is, and we intend to do this in the other body also, is that the Judiciary committees who are doing a deep dive into the justice system and understand the justice system would advocate with the Appropriations Committee in each chamber that it's time to look at funding the civil side of the courthouse, the courtroom. This is new for us. It's new for this legislature. It's new for our budget. But it's a small step, we think, in terms of guaranteeing civil justice to a large number of Vermonters. You heard what Sam had to say. You can look at the executive summary in his study that was filed with the committee. Yeah, before Judge Helen Tour retired, she spoke a lot about civil Gideon, trying to do on the civil side what the Gideon decision does on the criminal side in terms of providing representation. It's a whole different ballgame. It's a huge idea. We are not saying that $500,000 solves all the problems. What we're saying is it's a start. We can help a lot more people than we're doing now. So we hope that this committee will consider this request and bring it down the hall to the Appropriations Committee at the appropriate time. Happy to answer any questions. Hannah is here if you need more information about the foundation and its operations. Thank you for this morning.
Thank you.
Bob, I missed the last hour's testimony, and this was probably covered, but what would be the principles by which the grants would operate? So, understanding that they're civil matters, who would get a grant and who would not get a grant?
I think that would be up to the grants committee of the foundation. But I expect it to be in the areas where where there's the greatest need. And some of the
The
testimony,
geographic areas or the subject areas?
I think subject area, but I think also maybe geographic areas. And I think Yasmin alluded to this earlier about some of the, what we call legal deserts. Now, you'll hear that from Chief Justice Reiber. We heard about a lot about consumer debt issues. What was not mentioned yet this morning, and something that the Bar Association is involved in, is that right now we are a grantee from the Vermont Victims of the Victims of Crime Act, federal money, VOCA money. And we're able to find low bono attorneys to help victims of crime. That funding's in question. And we're actually right now not sure if we should be making new assignments or not, because we're not sure whether that funding is going to go away. So I would think consumer debt, victims, clearly housing issues. Family law is, the divorce, as Sam spoke, the normal divorce case where there's not children and there's not abuse, really pretty much unrepresented. And I'm sure if you sat down with Judge Zone, he can tell you just what the difficulties family court faces in terms of unrepresented litigants, either one or both in a divorce case. So I can't speak for the foundation, but again, their executive director is here.
Yeah, so the foundation, we have a committee of 6 folks plus.
Sorry, could you just identify yourself?
Yeah,
for the
Ian
record?
King, executive director of the Vermont Bar Foundation. We have a committee of 6 folks and then plus me, but I'm not a voting member on the committee. This is our grants committee. It is a mixture of folks that serve on the full Vermont Bar Foundation board. And then we also have other folks that are just volunteers. That way it gives us a diverse realm of opinion. And also they will make recommendations to the full board of who grant should go out to. Folks will submit grant requests, tell us how much they're requesting, what the project is. The committee discusses it and then sends it to the full board. If there's a discrepancy, then it goes back to conversation. In the past, we have tried to award the full amount that people request. There are instances where we don't grant any funding if the project just doesn't align or it doesn't seem as though it's sustainable and it's just not in the foundation's interest. Because we are so limited in our funding, we have to be very realistic about who we are awarding money to. And so it really is a committee's work.
And just to follow up to that, so I'm just trying to understand the basics. So the grant goes to an individual or a group to pay low bono attorneys, or the grant goes to the attorney?
It depends on the project. So the folks will submit a letter of intent. They're actually due next Monday, I believe, and that will kick off the grant process. And we're seeing proposals for low bono clinics. Legal Aid has plenty of different projects that they submit for. But then there's also one-time funding fees where if someone wants to stand up a domestic violence attorney for, one term, we fund that. So it really is a case-by-case basis.
So what we're funding are resources that people would draw on, not funding individual cases or claims or.
Not individual cases. The entire goal is just trying to expand the amount of legal access that we can provide. And so a lot of the times we're seeing grant applications that are focused on trying to hire more attorneys or trying to do low bono clinics or pro bono clinics, just because that is going to give you the biggest bang for your buck if we have more attorneys out there doing the work. But it is case by case.
And then the last question, the IOLTA that you mentioned, does that money go into the foundation?
Yes.
Yes.
So the foundation has assets now. This is just a request that we add to those assets.
Yeah, IOLTA funds, we are able to project out each year, so, which is really helpful because we know we'll have a base level of funding for the most part, but obviously that can fluctuate, just because IOLTA funds and the amount of cases that attorneys are doing and the amount of interest that is being paid is naturally going to change year to year, but we know in the past, it's been over $1 million comes in IOLTA funds, and the foundation, our job is managing that. And that is, I mean, everyone has talked about it today. There's such limited administrative capacity. I'm the only employee of the foundation. And so being able to fundraise is limited, but it is part of the job. So IOLTA funds does sustain a majority of the grants, but then we do have a robust fundraising committee as well to try to not have to rely just on that.
Thank you.
So the committee heard from Legal Services Vermont, Vermont Legal Aid, and the Vermont Asylum Assistance projects. You've heard from 3 service providers today. I expect that if the foundation is granted this money, there'll be a lot more people applying for it, not just those 3 organizations. I know developmental disabilities may be interested in it. Have Justice Will Travel may be interested in funding their projects. So again, we hope that you will consider bringing a recommendation in the appropriations project down to your committee. And any of us is available to answer questions at any time if they pop up. Thank you.
Thank you. Okay. Next up, we have Big Hartman. 15 minutes, that works for you? Does that work? 15 minutes or so work?
Absolutely.
Perfect.
Hi, I'm Big Hardman. I use they, them pronoun. I'm the Executive Director and General Counsel at the State of Vermont Human Rights Commission. Thank you so much for inviting me here today. On the topic that you're talking about, our office has a little segment of the civil justice work that's been described today. So we are a state agency. We are tasked with enforcement of the Vermont Fair Housing and Public Accommodations Act. And so that's mainly fair housing cases and cases involving discrimination in places of public accommodation. We also do a small segment of the employment discrimination investigations involving state employees only. So we provide neutral investigations. We process intakes, and out of all of the intakes that we get, we select some cases that we can accept for investigation. Then we provide with 3 staff attorneys who provide neutral investigations and try to facilitate conciliation or a settlement for the parties throughout our process. So out of the over 100 average inquiries we get in our office each month, a vast majority of them are not ending up a complaint. And very often we are providing referrals to the entities that you have heard from today, often unsure whether those individuals are actually going to find any support or legal services or advocacy. Many of the individuals who have complaints with our process are unrepresented. The majority of them are unrepresented people who come to a state agency asking for us to investigate whether what they've experienced is discrimination under the law. And there is a real shortage of civil and human rights attorneys in Vermont who have either the knowledge, expertise, or bandwidth to represent people in fair housing cases in particular, and who, have not those same knowledge, skills, expertise regarding public accommodations, which is primarily our Americans with Disabilities Act equivalent under state law. The very, very few complainants that do have representation in our cases are represented by Vermont Legal Aid, by their 1, maybe 2 attorneys who have extremely large caseload and represent folks in our process. But the majority of complainants in our cases are unrepresented while the majority of respondents tend to have lawyers. We're talking about a lot of landlords, property managers, business owners that have more resources, insurance policies and such that will be represented in our process. But our process is meant to be accessible and available to anyone, regardless of whether they have an attorney or not. So we have a total staff of 7 people, including myself, 3 of whom are the investigators. As you may recall, last year we were authorized to create a new position, which is a full-time litigator in our office, who's currently handling 15 enforcement actions in court by himself. These are cases where the Human Rights Commission is the plaintiff, and we have gone through the process of an investigation. We have found that there are reasonable grounds to believe that discrimination has occurred, and we have decided that the case should be pursued in court. We do not represent those individuals in those cases. We are still only representing our office. The Human Rights Commission is the plaintiff. So the role that we play in the civil justice system is to really provide some means of investigation and looking into a dispute or a concern about whether discrimination has occurred, and try to find out more about what happened, see if we can assist the parties with a solution, with finding a solution through facilitating conversations about settlement. And then, if a case, if we find that there's reasonable grounds to believe that discrimination occurred, we have the ability to pursue those cases in court. If we don't, or at any point, the complainant in those cases can have the benefit of our investigative file and go try to find a lawyer to represent them in court. But most of these complainants are people of extremely limited means. Many of them are Vermont's most vulnerable population, primarily people with disabilities and people of color. So what we see is that these folks already face a lot of barriers in accessing the justice system. So it's a real service that we can provide in being able to be a free government service of investigating these complaints and seeing what we can do to enforce the legal protections against discrimination that our state has. Any questions about any of that?
Just a technical question. I may have missed it, and just trying to understand how the Human Rights Commission is the plaintiff and the complainant. I'm just trying to figure out where does the complainant fit in, and what complaints, or like if something is going through litigation and then gets resolved, there's damages, but your office is the plaintiff. How does that exactly work?
Great question. In our lawsuits, the complainants are considered aggrieved parties under the law, and so they still have the opportunity to receive compensatory damages like pain and suffering or lost income or any individual relief. And we also have the ability to pursue what we call public interest relief, including injunctive relief, in order to stop doing the thing that's discriminatory, and civil penalties, as well as be awarded attorney fees for the litigation. And that's under the Human Rights Commission statute.
Thank you. Committee, any questions?
Just one more note I wanted to make about access to justice, and it's really about the time that these cases take. Because of our significant shortage of staff, our cases tend to take between 1 and 2 years on average to have the investigation go all the way. And that's just the investigation process, not the intake process, which can take months because we do not have a full-time staff member who can just take intakes. And it doesn't include our enforcement actions after the investigation is complete. So we have innovated our processes this year under my leadership as executive director to really streamline our investigative reports so that we're able to close out a lot more cases. And this year we did close out a significantly higher number of cases as compared to prior years. We're very pleased with that, but it's still not enough to meet the needs of the influx in the past year of requests for new complaints that we're receiving. Certainly in the past year, the number, especially of school cases where students are claiming that they have been discriminated against or harassed in our public schools has really increased in a very concerning way. We also have doubled the number of new fair housing cases that we accepted for investigation this year. And right now, those cases are largely we're closing out as much as we can, but many cases are stalled. I currently have over 20 cases that are sitting waiting for an investigator to be assigned to work on them because our staffing is so limited. So there is a proposal on the House side to increase our resources as well, with the hopes that with more staff, we would be able to process more intakes and do more investigations, because the reality is that every day I am turning people away saying we do not have capacity to investigate your claim, which could be meritorious. But with only 3 investigators, it's just very overwhelming for our team, as it is for many of the service providers here today.
Thank you.
Thank you. I have hard copies of my annual report. If anybody likes those hard copies, I've got them. If anyone wants one, they've been shared with the committee. Okay, great.
If I could get a hard copy, though.
All right. I also created in the last year, I created a guide for complainants and respondents because we really didn't have any plain language information about what our process looks like. So I'll pass that around if anyone would like one. They're just these great little booklets to help people understand our process. And it's meant to be both for complainants and respondents. I think you two already have this one. Absolutely. There you go. So that will help you as well if you're interested in seeing more about what folks can expect when they have a complaint with us. But there's a significant need for outreach work as well, which is a very small part of the services that we provide, and something that we really are getting an increasing demand for. Can we get a know your rights training? Can we do preventive discrimination trainings for businesses, for landlords, for property managers? And we do those as much as we can, but it takes us away from the enforcement work that we're trying to do as well. So that's another component of what we see as a real unmet need so far in the state.
Thank you.
Okay, thank you so
I
much.
just got one.
No, I was just gonna wonder, it says here FY 24 data, new formal complaints 57, but do you have any idea, I might need to keep flipping, but any idea of, how many you turn away that you can't turn into pursuing?
So we just started a case management system to help us get that data.
Yeah.
I could share my data for fiscal year 25 so far. So we're a little over halfway through the fiscal year, and I have rejected over 60 people this
It's
fiscal year,
almost like
while
over 50, yeah.
while accepting over 50. And there's many folks that we just say at the first call, this probably doesn't sound like something we can help you with. Here's Vermont legal aid's number. And we don't count those as cases that we turn away.
Yeah.
We just refer them on. And knowing that also many of the folks that contact us are in crisis and really need our time, need the time of someone in state government to hear them and to help them find a resource. And we absolutely do that as often as we can. But there have certainly been times in the past year where we have not been able to answer the phones for long periods of time. And it's very hard for everyone.
And then I'm just kind of curious about the housing portion of it. What's kind of like your number one biggest complaints that you get per for housing wise?
Great question. Most of our complainants are people with disabilities. People with disabilities have additional protections under state law, both in housing and places of public accommodation. So the most common run-of-the-mill fair housing complaint is about someone who needs a reasonable accommodation because of a disability. And it's been denied. And so we want to accept those complaints whenever we can. So there's really not another avenue that those folks are going to have for any kind of recourse. And it's an opportunity for us to educate the landlords about, hey, here's what the law is, you know, and also facilitate, can we find a solution so that this accommodation can be granted, you know?
Sarah Norris and then Bones.
Yeah, it appears as though you're all inundated with several complaints here. But my question was after passing out. What do y'all do besides media coverage? You're seeing you on TV for it. What's your outreach program looks like? What are you doing in that respect? How do they get? They seem to know how to get in touch with everybody here, but what do you do for outreach?
I'll just speak to me. I know these folks have a whole other set of projects on outreach. We have one staff member who is our director of policy education and outreach. So it's a portion of her work is to oversee some of our outreach. And the more outreach that we do, the more complaints we receive that we are not able to process. But I do think our numbers are higher because of the outreach that we've done. So we try to go to events. We try to go to other conferences that are happening. We host a free virtual fair housing training every 2 months that anyone can sign up for. It's usually landlords and property managers, but we have no outreach budget. We have never been given a single dollar for outreach. The only way I was able to print this guide is because I had a little bit of HUD money that HUD had given us for fair housing outreach work and education. But it's a real problem, I think, that we really don't have the ability to put out public service announcements to really do the preventive work that we would like. And I think people find us because they search Human Rights Vermont, and that's how they find us.
And I'd say, I mean, again, I'd say the biggest way that we reach people initially is probably through web searches. We have that public information, legal information website that gets 600,000 page hits a year. So people are searching, finding things that way. We do a lot of posts on social media, mostly informational posts, but kind of to keep our name out there. The toll-free number, which is for both us and for Vermont Legal Aid, we get out. I mean, it's in a lot of print formats and a lot of official legal notices. We try to make sure that number gets on there. For example, when somebody receives a denial from most state agencies, especially social services, DCF, things from economic services, that number is going to be on that denial letter, so that people know that they can call us if that's what they're doing. I mentioned the court outreach, when the eviction cases are filed, that we're sending those letters. So we do and we maintain a lot of communication with community partners, social service providers, just make sure they know that we're out there.
I mean, Vermont Legal Aid is grappling with the same things as the commission, and we don't have like a formal organizational outreach person on my wish list of things. So our outreach, for instance, like our social media and whatnot, is kind of, it's not really consistent, which isn't the best, but the way people kind of find us is through our partners, through referrals. When we do community clinics, if we do community visits, folks who are calling Legal Services Vermont, and it gets sent over to us, depending on the project may have a hotline, and they kind of do. Sometimes they'll do their own form of outreach. Our health project, which is going to end in July, was sending affirmative letters out for folks who are facing eviction to get in touch. And so the methods for outreach vary and are not as consistent as we would like. But obviously to organize outreach takes resources, and we've heavily invested in helping people through direct legal services, but obviously it would be great to be able to do more outreach.
And if I may, Senator Norris, the shortest answer to your question is that I don't sleep. And I say that, it's funny and it's true. And And like I say it to honor my wife, who I actually met bringing fair housing complaints to the commission in 2018. And that's how we met when we were working together at Vermont Legal Aid. But in a real sense, the challenge that we face in a program like ours, where it's us, is not only are we trying to bring awareness to the issues, awareness to the shortfalls, but we're also trying to build trust with a community that is being taught to distrust government and representatives of government. And so it's actually been really challenging to find the time to be out in community, at community spaces, in community groups, being a presence, being a person, so that when I call someone to return a call back requesting intake and I say, hi, it's Jill, I'm a lawyer from BAP, they don't think this is immigration, click. And that's been a structural barrier. And I think part of vulnerable population, like we know that there's a big gap between who has the highest needs in Vermont for civil legal aid and who's actually getting access to justice. And a lot of it are these like structural barriers, the inherent inaccessibility of intake systems, the structural fear that communities of color have engaging with our services. And this happens to be my life's work. I'm just like a toxic white person with no kids. And so I can carry on the way that I do. But it's a problem, the lack of outreach and infrastructure to build confidence in our civil legal system for the people who need us most.
Senator Bohosky, the last question.
So I have two questions. One is how you decide which cases you take and which cases you reject. What's the algorithm for that?
Great question. It's a hard decision every single time. First, I make sure that someone can articulate what we call a prima facie case, right? Can you make out the essential elements to plead a violation of law? Sometimes, and if they can, which many times they can, but I still don't have resources, if we're talking about a highly complex set of facts and other challenges that will increase the burden on staff, I'm going to opt to reject that claim in favor of being able to process more cases of another kind that would take the same amount of staff resources. So if they already are within the 1 year of the last discriminatory act and they've made a prima facie case, then it really comes down to an exercise of discretion. And it's very gut wrenching to have to say no to folks who already distrust the systems. And now we're abandoning them basically. But I also have a problem with accepting a case and then having it sit, not having a single staff member to work on it for a year. And that's where some things are at right now.
Thank you. My other question came up as you were talking. What's your relationship with Disability Rights Vermont? Aren't they also doing disability law?
Yeah, so Disability Rights Vermont and Vermont Legal Aid are the two only entities that I see representing complainants. So they provide legal advice and advocacy for complainants in our cases. We are often referring cases to both of those offices, unsure whether or not they ever end up getting representation from those folks. Disability Rights will also refer cases to us, say, we can't represent this person, but here's the facts. Will you investigate? Yeah.
So I tried to give you a little bit of, because we also work very closely with Disability Rights Vermont. They're a very small agency, very, very tiny. And they actually grant some of their money to Vermont Legal Aid to do some of exactly that work. And that's actually the same pot of money. Disability Rights really focuses their attention on institutional disability issues like Brattleboro Retreat or the prisons. That's the primary focus, and most of the funding for anything else is what Vermont Legal Aid is doing. So.
Thank you. Appreciate it. Next up, we have Eric Fitzpatrick, and we'll be talking about S3. Going to be a very exciting bill about transfer of property to a trust. Eric, you're good to go. Absolutely. Great.
Is this a tax issue?
Sure. I don't think tax issue, but it's more creditors going after joint tenants.
Yes.
Thank you.
First time seeing you this? I know, first time for a walkthrough this year. I really
No, we might be 5 or 10 minutes behind.
Oh, you're right, there was a spontaneous one, the other trust bill, actually.
Yeah, some of your chickens bill about
Right,
property trust.
yes, that's for trust.
Nothing against it. Sound riveting.
Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here as the chair indicated to talk about Senate Bill 3 Act relating to the transfer of property to a trust, which sounds like it's a bit of a change in gears from what you were speaking about in the prior topic. So very different, kind of illustrates the breadth of the jurisdiction the judiciary. For a moment or two, I think it wouldn't take long for this bill to see that there's a lot of highly legalistic language in it. That's the nature of trust law. It's complicated legal instruments that many people use for estate planning, but generally require attorneys to adhere to very specific legal language, and that's why you see it in front of you. So before I even mention the language, I'll just throw a couple of background concepts out there that might be helpful to keep in mind when we turn to what the bill proposes to do. So remember, as Senator Byhowski mentioned, I was speaking about trust in the context of a different bill a week or two ago. And you may recall just one point that's helpful to keep in the background about trust, because this proposal is although it involves both property and property transfers and trust, it's in the trust section of the Vermont statutes. So remember, with trust, generally speaking, you have three parties involved. The three are the settlor, the trustee, and the beneficiary. Those are the three. The settlor are the person or persons who put the property into the trust. So that I want to put some property into a trust. The settlor is what that person or persons is called. The trustee is the person who manages that property. And legally speaking, they are the owner. They're the legal owner of the property. Although they are under legal and fiduciary obligations, in other words, because they own it, they can't just take it. For example, they are under legal obligations not only by the trust document itself, the trust agreement articulates what they have to do. The law does as well. They're a fiduciary of the trust, so they have many legal obligations. But legally speaking, as well, they do own that property. Beneficiary is the person who the property is ultimately, or sometimes during the course of the existence of the trust, distributed to. So they're the beneficiary. They receive the benefits of this property that's in the trust. So you have those three parties. Important to keep that in mind when we talk about what's going on in this bill. So this is about a transfer of a particular type of property into a trust. And this type of property is property that's owned, what's called tenants by the entirety, a tenancy by the entirety. That is a method of property ownership that is generally reserved for spouses. So people who are married can own property that's tenants by the entirety. It's a method of more than one person owning property. There's other methods of that. They can be a joint tenancy, tenancy in common. There's other methods that more than one person can own property. There's only one that's reserved for spouses, and that's this one, tenancy by the entirety. So, and it's been in existence in Vermont for, literally hundreds of years. Dates way back to this common law, this method of ownership. But one of the primary features of it is what's known as creditor protection. And that's the idea that if the spouses own this property as tenants by the entirety, they each own what's known as a 100% undivided interest in the property. In other words, it's not 50-50, right? That's the other one I mentioned, joint tenants. You can own property. You don't have to be married. You can own property with anybody else, a friend of mine. I mean, say we want to own it together as joint tenants, and you divide it up equally. So I own 50%, the other person could own 50% if there were two of us. The sort of legal basis of the tenancy by the entirety that spouses own it is they each own an undivided 100% interest. So I own 100%, my spouse owns 100%. What that means is a creditor, let's say I own property with my spouse, tenancy by the entirety. I get into a car accident, it's my fault. So I get sued. My spouse didn't have anything to do with it. It's entirely my fault. the person who gains a judgment against me or any other kind of creditor wants to attach my property to pay for the lawsuit that they won successfully against me. And I happen to, just picking an example here, let's say my wife and I own our house as tenants by the entireties, they can't attach, they can't go after it because we each own a 100% undivided interest in the property. So since my wife owns 100% too, they can't attach that because she didn't have anything to do with the car thing. She's not at fault. She's not the defendant. So the result of that is, in a nutshell, creditor protection for people, spouses who own property as tenants by the entirety. So in other words, the creditors of one spouse can't go after the property because the other spouse owns 100% of it also. One of the primary, if not the primary, benefits and advantages of owning property in that way.
Eric, one question for you. When one of the spouses dies, and let's say they have debt of some sort, that debt can't then follow the other spouse, the living spouse, in a way that the creditors will go after the property that's in that joint tenancy.
I think that's correct. I think that's correct.
So how or would that be impacted by the dissolution of that marriage? My understanding is that when you enter into a marriage contract, you together own all debts and assets. So how does this play with that? I mean, you don't know.
You mean like in terms of maybe how the property is divided upon dissolution of the marriage?
Maybe, or does that suddenly mean that both, like if the marriage is dissolved, would that now mean that creditors could go after either one? Like I'm just confused how it all plays together.
Well, in this particular context, it's specifically addressed that concern. And I don't know the sort of bigger picture context as to how that would affect all property that the spouses own. But in this particular context, that's provided for in the bottom of page 3. It says if the marriage is dissolved, then they don't get the immunity.
Okay.
So then,
yes.
Yes, exactly, right.
But that's new language, right?
Correct.
And I thank you for the basic explanation of the terms and such, but what, if you had to summarize it, what is the problem this bill is?
What it's addressing is that so we just described the two situations. So it's sort of how the tenancy by the entirety works and how the property, who the parties are with respect to a trust. So what this is addressing is, let's say the married couple wants to, or they're involved in planning their estate, writing their will, and what's going to happen when they pass away, that sort of thing. One of the things which is frequently used in estate planning is creating a trust for somebody's property. So they decide they want to put some of their property that they own as tenants by the entirety into a trust. The issue is that if that's done, then this creditor protection feature that is part of tenants by the entirety doesn't last. That cannot occur currently under the way trust law works, because remember I mentioned technically the trustee is the owner of the property, not the married people. They don't remain the legal owner after the property is transferred to a trust. So that creditor protection point that I just mentioned would go away. And there have been a number of states that, first of all, not all states have this tenancy by the entirety option. So I think it's about half. Vermont's one of the half that does have it. But of the states that do have it, a number of them, I think 12-ish have adopted a statute like the one in the bill that you're looking at, which is to say, addresses your question, Senator Bruce. What's this attempting to do? It's attempt to say that one of the benefits of owning property as tenants by the entirety, this creditor protection feature, will stay with the property if it's put into a trust. That's it in a nutshell.
And can I ask, and maybe this is just reading that phrase tenants by the entirety too literally, but it seems like if you're talking about a house and you and your spouse own it jointly as tenants by the entirety, you are maybe actually tenants of the property. And so giving you creditor protection protects your place where you live. But if you convey it into a trust with a beneficiary, then by definition, it's going to somebody else. So I guess my question would be, why does that beneficiary's interest outweigh the interest of somebody who won a judgment against you and wants the judgment settled? Because if we change it, we're just shielding more property from people who have a legal right to be paid by, right?
Well, I think the idea is that it doesn't change the status that the property has currently. You know, that if it's held in this tenancy by the entirety fashion.
Yeah, but I mean, it, at least, and I don't know what I'm talking about, but just from your quick discussion, it sounds like if I and my wife have the money to, you know, go to a lawyer and have this as tenants by the entirety, and then we decide we're going to convey that to our son. We're going to have a trust for our son. And so we're going to put it into this trust. But one of us is found guilty of, you know, hitting somebody with a car,
Sure.
killing them.
Yep.
We've shielded the son's interests, not the place where we live. We've shielded the beneficiary's interest from the creditor. And then it seems like we're just extending that protection out from the tenants, out from the two people, the spouses, into other people that they might make beneficiaries. And so I'm a little sympathetic to the person who recovered in court, but can't get to that property because it's being conveyed to a third party. Does that make sense?
Yeah, it's an interesting point. I think it's more about a policy question, sort of balancing the interest there. Which is, fair question. And I think I tend to defer to the witnesses on it, but I think I see your point.
Thank you.
Yeah.
Senator Mallett.
You wouldn't put your personal residence in a trust for your child. Wouldn't you put your personal residence in a trust and then that you and your spouse are the trustees on, and then they would be beneficiary down the road of that? It wouldn't be a trust named. What?
Sorry, I was talking about generally estate planning.
Yeah.
Yeah.
Right.
Then you would be a tenant of your son's house.
Yeah, although the word tenant can be a little misleading here.
No, I know, but I think you, in that case, because you would convey the title of that property to the trust of your son, you would no longer own that property.
That's right. Technically.
So you'd actually literally be a tenant of the house. Therefore, if you got sued, that asset is not something they could go after anyway.
If
Because you're just a renter.
well, you aren't an owner.
Right.
Right. And I think that if you've been a settler and transferred the property into the trust, then you aren't technically the owner anymore. I don't know if that's an interesting legal question. Would you? I don't think you technically be a tenant, but I see what you mean. It's sort of a similarity there in that you aren't the owner anymore either.
Yeah.
Right. Whereas whether it's the child or whoever's the beneficiary of the trust could get it later on. And yeah, that is a estate planning thing that sometimes people use trust to avoid probate for that reason.
Yeah, that's a big one. Yeah.
Exactly. I mean, trust is a way to do that.
And the tenants by entirety concept strikes me as reasonable, as does estate planning and other things like that, protecting your assets. I'm just wondering here about where we're taking this protection and transferring it out to if the property goes into a trust. And I just don't know how I feel about that additional step or what the actual reasons are for it.
If my wife and I own our house and we're tenants by the entirety, that's already covered. Creditors can't come after.
Correct.
Not even in a trust. So this.
Then I don't understand why they're needing to put it in trust, because they already have protection as tenants by the entirety. So it seems like it must be covering if somebody else is the beneficiary, a child or somebody else. And I don't understand then why we would protect that third person's interest. Because then you're just saying you can never recover from this person because they've, so I don't, and it need to be a child. They could, right?
Whoever, yeah.
They could say, my friend from high school, I want them to have this house when we die. I don't know why we would prefer that person's interest over the interest of somebody who in a court of law was found to be owed money. You know what I mean?
Yeah.
So anyway.
I think Mark Langen could clarify a lot of the questions.
Okay.
Or perhaps provide more information if you'd like to testify. But well, before we start, are there any remaining questions for Eric?
Now, anytime you get this many attorneys around, they're just not involved me here. I don't know what you're.
I don't know.
Mark, yes, please feel free to share your thoughts.
Thank you. Thank you very much. Maybe I can give you a little history on this statute that came about, exactly what it does and that sort of thing. Just a slight primer on owning property together. When more than one person owns property, there are actually four, but I'll one so most people don't know about. So there's basically three. One is tenants by the tenants in common. So if we own property together, tenants in common, if I die, my share goes to my family or according to my estate plan. The general rule is that, let's say if you have three tenants, the law presumes each owns a third. The presumption is rebuttable. It may be, 50, 20, 30. You can rebut it, okay? The second level, which New Hampshire, most states recognize, is joint tenants with rights of survivorship. So if three of us owned property as joint tenants with rights of survivorship, he who lives longest wins. Okay, goes to the survivor. But in joint tenants with rights of survivorship, let's say in New Hampshire, which doesn't recognize tenants by the entirety, husband and wife are each presumed to own 50-50. Presumption is rebuttable, but 50-50. But and it's an undivided 50-50%. But if, let's say, husband causes a car accident and gets sued, creditors can attach 50%. Okay. Then tenants by the entirety, which is an English concept, and Eric is correct, it's about half of the jurisdictions that would still retain this old English concept, is that husband and wife were deemed to be one person. And therefore, each owns the whole. They each own 100%. So if husband caused a car accident and they go after him, they can't attach it because wife was not the tortfeasor. And that's been around for centuries as our law. Interesting in Vermont, while the general rule is that the law presumes tenants in common over other forms of tenancy over joint tenants with rights of survivorship, tenants by the entirety. In Vermont, tenants by the entirety overrides or supersedes other forms. So just the mere naming of the husband and the spouses without anything further is tenants by the entirety. You don't have to specifically say we're holding it as tenants by the entirety. It can be silent. Whereas with joint tenants with rights of survivorship, you have to specifically say that. Otherwise, you will be tenants in common. Okay, so that's the rule on tenants in common. So what we find in estate plan, yes.
If I can interrupt, Senator Mattos has a question real quick.
Sure.
Mark, real quick, what happens in the case where two people are together, one owns a home, they get married, they still live in the home, but it's still only owned by one person. So once you get married, the new spouse, so to speak, is now an owner of that property automatically. Is it automatically tenants by the entirety, or how does that work?
No, let's say that the property was in the husband's name. They get married, they don't change the deed. It's still in the husband's name. It's not tenants by the entirety property. The spouse has a homestead interest, but there's no tenants by the entirety. You have to have that joint ownership. Okay.
So how come?
Also, I had this case, couple living together, bought the house together, got married. We had to redo the deed because it didn't convert from joint tenants with right survivorship to, or tenants in common to tenants by the entirety by the mere fact of the ceremony of their marriage. We had to redo a deed to put it into tenants by the entirety. So
Okay. I've got to the closing table before in that example, and they asked the question, are you married? Yes. And the husband's the only person on the deed, and we had to wait and get the wife to come in and be able to sign off on the deed as well.
yes, because she had a homestead right, and they want to make sure that she's giving that up. Yeah.
Okay.
Yeah. So so then from an estate planning point of view, as a practical matter, when we have clients who are in high risk occupations like a cardiothoracic surgeon or something like that, we generally like for most of our clients to put their residences in trusts so that they will avoid probate administration. It just makes it easier for administering the estate after someone dies. But we're fearful with people who are in high risk because they do have this protection under the law if they hold it in their individual names as tenants by the entirety, which Vermont has always afforded that protection. And so we don't put it into trust, and we just say, hey, when you retire and your insurance tail runs out, then we'll and you're beyond statute, people suing you, you can put it into your trust if you live that long. But the problem is that we find is that when one spouse dies, and now there's two features. There's the creditor protection, but there's also he who lives longest wins. So there's the automatic transfer because remember they own 100%. So if one person drops out, the other person owns 100%. But if that spouse, the surviving spouse, now we have a probate asset potential, unless they do something. And they might not do something because they have dementia, or they forget about it, or they have reason. So my colleague, Steve Unsworth, has been pushing for a long time isn't there a way that we can get the benefit of both worlds of maintaining that creditor protection feature of tenants by the entirety, but still just avoid probate administration for the ease of administration of our estates. And that's the only thing the statute really does, that is to avoid probate administration. The statute provides in it that when the husband and wife or the spouses, they transfer the property, they could do it to a joint trust or to their separate trust, they must be the beneficiaries. Okay, if they're not the beneficiaries, then you're not going to have that issue happen. Okay, they have to be a beneficiary to maintain that creditor protection feature. When one dies, we lose it. The creditor protection is lost. Okay.
Mark, can I interrupt real quick just for a clarifying question that I think will get to Senator Baruch's point? To what you just said, the two individuals who are tenants by the entirety, they have that protection against creditors. They enter into a trust and they themselves remain the sole beneficiaries, but there isn't any other third party, like a son or a friend. And in only the case where those two tenants by the entirety enter into that trust, that's the only scenario in which the protection continues, right? Was that what you just described, or did I misunderstand?
No, I don't. Let me just read. I'm at. This is C1D. That is if both spouses are current beneficiaries of one joint trust and hold the entire property, or each spouse is a current beneficiary of a separate trust, and the two separate trusts together hold the entire property, whether or not other persons are also current or future beneficiaries of the trust or trust. So in the example, let's say if the son takes after the parents, which is 99% of the cases, that's okay. The trust could say, okay, son, you get the property when the second of us dies. That's the way most trusts are written. But the statute is broad enough that there could be another current beneficiary, but the spouses have to be current beneficiaries. And once you lose one spouse, you lose that credit protection feature about it. So it's a little bit more flexible to have co-beneficiaries, but the spouses have to be there. So it's only during their lifetime. So
And then if Mark, just to extend that, so if the parents are the beneficiaries, but they also have some unrelated folks, not even their children, but their separate trusts have other beneficiaries. When they die, the protection ends. And so then it's just a normal relationship to the property at that point with the beneficiary.
correct.
Okay.
That ceases. So
Before you start again, Senator Hosty also.
Well, so now I'm even more confused than I was before, because I thought the whole point of this was to protect a beneficiary, say the son, from creditors going after them for a mistake the parents made. And now you're telling me that that doesn't exist.
no,
Could be anything.
So what's the point of this?
avoid probate.
On the protection of tenants in the entirety when a property
During
is
their
transferred
lifetimes.
into a trust.
That didn't help at all, but okay.
Yeah.
So about
So,
go ahead.
I was just gonna say, so it's allowing the couple, let's say, to get the benefits of tenants by the entirety and the benefits of avoiding probate and making sure that their assets get conveyed without probate to the beneficiaries, which I guess still leaves me with my original thing where we're basically, through a complex series of mechanisms, we're protecting the interests of somebody who's perhaps unrelated to the couple over the creditors who can't get this property at all. It's removed from their.
Well, they can't get it until one of them dies, and
Well-
then they can.
No, because then the other one gets it, right? Or if one of them dies, then this is so fun.
If one of them dies, right.
It goes, what Mark just said, it goes away. So if one of them dies, then it is no longer protected.
So even if it's in a trust, if one of them dies, then the creditor could attach at that point.
Well,
Well,
I think
it depends on who dies. Do
Right.
the tortfeasor die or the other spouse?
Right. If the one who died was the one who committed the tort, who wrecked the car, then I don't think they can get it. Because
Unless it's
then-
one of the spouses.
Unless the,
Because my understanding is it only works if both spouses are alive. So if one of the spouses is the ones that committed the tort, then the protection does go away. But if the beneficiary was the one, then
I think if the spouse who caused the fatality in the car accident survives, if that's the one who lives, and the spouse who dies is the one who had nothing to do with the car accident, and I think that surviving spouse could still be liable. Is that right, Mark?
Correct.
but if the one who did the car fatality is the one who dies, the other spouse is still protected?
If,
I think-
if the tortfeasor dies first, the other spouse is protected because she owned the whole anyway, and the other one just dropped out. And that's the way it works currently.
We're in going tenants by the entirety.
Pardon me?
I'll withdraw the question.
I want to try and ask the same question. I was going to, is that true? Whether or not the property, let's say they never put it into the trust. In other words, does the surviving non-tortfeasor spouse remain immune from the creditors, whether or not the property stayed as a joint tenancy and they never put it in the trust, or is the same thing true if they put it in into a trust that we're talking about here?
The liability doesn't, those rules don't change. So if the non-tortfeasor is a survivor, the creditors are out of luck to get that asset. Because, and frequently when you're trying to attach the asset of a decedent, and generally if it avoids probate administration, it avoids creditor attachment for the most part, particularly with credit cards, I'd say. We find that credit card companies, a lot of times when people die with a balance on their credit card, the companies never really go after the estate.
Although they try.
But they can try. And I have seen it just recently. We settled a few credit card claims of the decedent. But as a general rule, let's say if it was the house and the tortfeasor died first, the surviving spouse would maintain the house and it wouldn't be subject to attachment because it wasn't before, We're not changing the rules that already have existed in this state since its beginning.
Senator Norris has a question and then Ruth.
Yeah, thank you, Mark. My question is, in looking at this bill, trying to understand it, I might add, let's say that a married couple have set up revocable trust up with their children as sole beneficiaries. They own the house, the assets, the property, whatever else, but it doesn't go into effect until the last member, either the husband or the wife, passed away. Does this bill help or hurt this trust that was set up for those 4 children that they had?
If I was just a clarifying question, are the children co-beneficiaries with the spouses?
They've been listed on the trust as co-beneficiaries.
Yeah, as long as the spouses are beneficiaries of either the joint trust or their respective trusts, then we have the creditor protection feature would hold. But I think that as soon as one spouse dies, then we lose the tenants by the entirety, and then we just talked about whether a creditor could get that or not. It depends on whether the tortfeasor is still surviving and took the whole, or whether the tortfeasor was the first one to die. And not only tortfeasors, but creditors, or the borrower, that sort of thing.
So, Mark, I'm just wondering, is it possible to say the following? That the only thing this bill would do is, in addition to the creditor protection, these people would now have probate protection, but nothing else would change?
It's correct. It's the only thing is being able to maintain what people are doing, which is holding it as tenants by the entirety, but put it into trust so that it would avoid probate administration down the road. It's the thrust.
That makes more sense to me in that already with the creditor protection feature, the creditor can access it. And so it could be transferred just by normal willing the property to a third party, and it would be protected. So this isn't adding any. So maybe it was a red herring of me to be thinking it was adding the ability to transfer it to a third party with protection that already exists. The only thing you're saying is that the state will not get involved, the courts will not get involved in probate if this gets put into a trust.
Right. That's the import of this statute. And about 16 other jurisdictions have similar statutes or of one kind. We looked at all 16 of them. This is a subcommittee of the probate and trust law section of the bar. And we had probably about 8 members. We among them, Jim Knapp, who was a section chair of the real estate section. I'm the chair of the probate and trust section of the bar. So that's the import of the global thing. It wouldn't change the liabilities that exist right now.
All right, thank you.
This,
If I could, there's two things though.
well, one second here. Senator Hosty had a question and then we can.
Explanation answered my question better than I think anyone else could.
This amount of confusion is how I spent every day of the summer 2 years ago. So it's great. Sorry, Mark, please continue. Or, sorry, Eric has a question.
Mark, and this kind of was I was a little not unsure of Senator Ruth's question earlier on about whether there could be beneficiaries other than the spouses themselves. And it's really more of a drafted question. I know I redrafted some of the language, so maybe I missed something here. And I'm looking at page 3, line 5. And I hear what you're saying is that the intent here is that the spouses have to be beneficiaries of the trust, right?
Yes.
So I wonder if maybe I phrased that wrong, because it says that's the list of things that have to apply. And D is the property is a spouse's property, including if. But I may have to rephrase that because I think if I'm understanding right, that doesn't necessarily say that I don't think that the spouses have to be beneficiaries, including if, as opposed to, anyway, it's more of a technical question. Just ponder it and I can circle back with you. I wanted to just mention it now while we're all talking.
Okay.
Thanks.
Mark, can I give you 5 more minutes? Would that be sufficient? I just want to give the committee some time before the floor, and I'm sure we can take additional testimony the coming weeks as well.
Yes, I have. So as frequently as the case, when these bills come up for a hearing, I start to get people coming out of the woodwork and saying, "Oh, we want this change. We want that change." There's 2 that I want to talk to. I've sent to Eric. Jim Knapp of the real estate section was concerned about, it wasn't clear to him whether would this apply prospectively only or retroactively. And the committee felt that it would apply retroactively, so that if you have tenants by the entirety property, or if it wasn't tenants by the entirety and you transferred it to your trust, you would be protected. So it would work retroactively. And I sent some language to Eric that would take care of that issue. The second issue, I heard from Chris D'Elia of the Vermont Bankers Association, and he is concerned that he would like some affirmative language that says that that this statute would not override current contractual obligations with lenders or mortgagors. So, and I didn't think the language is absolutely necessary, but I have no objection whatsoever to having some affirmative language in there that says that this statute does not override currently or existing contractual obligations or any obligation that they make. So this raises to the earlier point, let's say if one spouse is on the deed and goes for a mortgage, they're going to have the other spouse at least sign the mortgage to give up their rights and, both their homestead right, but their, if there's any creditor, they can't claim that I'm a tenant by the entirety. But they couldn't because they're not on the deed. So they have to be on the deed to do that. But and if they're both on the deed, then if the bank is lending money to them, they're going to require both of them sign the promissory note and both of them sign the mortgage. So,
and Chris in the room, I'm sure we'll, when we take it up again, we can have him testify as well, just to provide some additional context. Senator Matos, you have a question?
Yeah, Mark, back to my earlier thought, going to take it one step further now about the mortgage part of it. You have 2 people. One bought the house. They're the only one on the deed, only one to get the note for the mortgage. They get married and then transfer this into tenants by the entirety. And then the person who took the mortgage out passes away. Who's responsible for that mortgage? And if anyone, then? Because would they have to sign a promissory note when it goes into tenants by the entirety? or what?
Okay, so when the owner of the property dies, there's a transfer of the property, whether to his estate or whatever. And the question is can the bank exercise the due on sale clause? Anytime there's a transfer, they can say, hey, your mortgage is due, pay us off right now. The federal government passed a statute called Garn-St. Germain in 1982, and it said that if the mortgage is backed by us, the federal government, then we're going to make some exceptions to the exercise of that due on sale clause. And if the property is passing to an heir or a family member, you can't exercise the due on sale clause. So family members, if let's say the mortgagor dies and the surviving spouse or the kids, whatever, if they continue to pay the mortgage, you know, the bank can't say, oh, we're going to call this 2% mortgage and you can refinance at 7%. No, the family is able to continue on with the mortgage, but that's a federal law that allows that. I would say that I venture a guess, I think almost every mortgage in the United States is backed by the federal government through Freddie Mac, et cetera.
Well, thank you for your time. Appreciate it.
Thank you for your consideration. I appreciate it.
Well, I'm sure we'll revisit this and try to get a refresher, fully understand it. And also hear testimony from other folks as well, like Chris. And yeah, I'll take it from there. So we are good. We can